Any mention? May it please, Your Lordship. Your Lordship, I beg to mention item number 27, Your Lordship.
Why?
The conducting counsel, Mr. A.G. Momin, having some personal difficulty, Your Lordship.
You argue it.
Lordship, it's a joint request, Your Lordship.
Joint request, Lordship.
So jointly argue then. What is the problem? Okay, 2 weeks, yes.
Highly obliged, Lordship.
Yes.
Lordship, I beg to mention item number 17, Lordship. I'm for respondent number 1.
17.
17, yes, Lordship. I need some more time to find my counter affidavit, Lordship.
Is it the hearing list? No, it's not the hearing list. 17. Will it come back be called out, Mr. Nokala?
Pardon?
It's in the order column. 17.
Yes, Lordship.
It will be called out, yes. Yes.
My Lord, I pray to item number 31, my Lord. Requires some preparation in it.
But you want to require some?
Preparation in the matter.
Why not prepare today?
No, my Lord.
You can prepare as you go along. Okay, 2 weeks, yes. Request, Mr. Jahan. No objection.
No objection, Your Lordship.
Okay. Yes.
Highly obliged.
Much obliged, Lordship.
Please, Your Lordship. Lordship, I beg to mention item 29. Lordship, the conducting counsel is indisposed, Your Lordship.
Oh, Mr. Gautam.
Yes, Your Lordship. I prefer 2 weeks' time, Your Lordship.
Okay, 2 weeks, yes. That's,
Obliged, Your Lordship.
yes. Someone mentioned, make it quick, yes.
Lordship, I beg to mention item number 28.
28.
Yes, Your Lordship.
This is the matter relating to
Yes, sir.
implementation of SETI Commission report, my lord. Similar matters are also pending in Supreme Court, in where the notices have been issued, my lord.
So the transfer is there.
So then this matter can be kept pending, awaiting the outcome, because there is a All India Federation of Employees, High Court employees, which has filed the case, my lord.
What to do?
Let it come up after 2 weeks, Your Lordship, because senior counsel is leading us in this matter, Your
Who's the
Lordship.
counsel?
D.K. Mishra.
D.K. Mishra
Yes, Your Lordship.
from Guwahati.
Yes, Your Lordship.
Okay, Mr. Learned Advocate General has submitted that similar matters with regard to implementation of the SETI Commission report are awaiting consideration before the Supreme Court. He prays that since this matter is, will this matter be listed after 3 weeks? Yes, to await any outcome, yes.
Obliged, Your Lordship.
May I please, Your Lordship? I beg to mention item 19 and 20.
19?
19 and 20. The connected matters.
Why?
Lordship, connecting counsel is on sanction
Who
leave.
connected counsel?
H.L. Changraiso.
Who?
Shri H.L. Changraiso.
You here? This matters in the last stage.
Yes, Your Lordship.
Who's the other? Where's Mr. What's that? Who was appearing with them? Mr. Dokrut. You're here? We'll finish up the matter today.
I didn't have the instruction from my senior, so
Why?
I also.
You know, it's always other round. Junior instructs the senior. Senior is engaged you for a day.
It's regarding to this last matter. Actually, he had collected some documents day before yesterday with me, but I didn't know that he has to go for
I was not
urgency.
inclined to adjourn this matter any longer, actually.
He has to go for his urgency because of his medical checkup.
What to do?
It's not
Tomorrow?
because of him.
Next week, Your Lordship.
Next week,
Yeah,
after
just
1 week.
week,
yes.
he will be okay.
Fixed date, huh? After 1 week. After 1 week. Okay, otherwise, yes, okay.
Next week.
Yes.
Lordship, similar prayer for item 30.
Item
30. I'm for respondent number
30.
5. I'm appearing on behalf of respondent number 5.
You totally decimated the hearing list, yes.
Your Lordship, may they be granted one last opportunity?
You want to do the hearing today?
Yes, Your Lordship.
Yes.
Yes.
You've read the file? No. Okay, 2 weeks. Yes, MS Iwanyang raised that due to the unavailability of the senior counsel, the matter we adjourn for 2 weeks. Stop. You're Mr.
G. Sinkram, Your Lordship.
G. Sinkram, right? Mr. Petitioner, do others objections. However, submits that this may be the last opportunity given. Submission noted. This is matter for 2 weeks. Yes.
Very much.
Supplementary list item number 1.
Was this moved earlier?
Yes. Earlier I have challenged in another aspect, and today I am challenged another.
Challenged in another?
In the earlier petitions, we challenged the election of the new manager MC, madam. And today, before my lord, is the grievances petitioner. She has been reduced from the post of head teacher to the post of assistant teacher. So we have verified that.
First, she was removed from secretary, made
Yes.
head teacher.
Yes.
Now, second demotion from head teacher
Yes.
to assistant teacher.
To assistant teacher.
What is this? Yes.
Yes.
That's what I thought. Yes, within. Where's the impugn order?
Impugn order, page 51, my lord.
Page?
51.
Does this need approval from the SDSU?
On the no. The other is still reads, my lord,
But
on
then
the
why he's
recommendation of the
approved
MC.
Who's the Torpunio Sangriang?
Is the respondent
senior to
number
you?
4. Respondent number 4.
Is he senior to you in the school?
No, I'm senior to him.
Yeah, Shulai, what is this? This punishing a person because she came against
may
the
please your
illegal
lordship,
reconstitution of management committee from secretary. She should be secretary head teacher. Now you reduce her to.
Lordship, kindly come to page 36. In 2001, Your Lordship, there was a resolution of the managing committee, Your Lordship.
In
2001, Lordship, kindly come to page 36, Your Lordship. So it appears, Your Lordship, that this resolution has not obtained the approval of the competent authority, Your Lordship.
In 2001.
Yes, Your
Now
Lordship.
now in 24.
Lordship, because what happened, Your Lordship?
We will. This is absolutely. You see, there's something as. You doing a witch hunt, against the teacher, raise the voice against the person's as per Perma Fasai, it looks he abstained from the first meeting and reconstituted the managing committee himself. And then now he made her a teacher.
Lordship will have to wait for the version of the other side, Your Lordship.
Whatever version, whatever appears to the eye now, let them come.
Because
see this order.
It appears, Your Lordship, that no approval has been obtained, Your Lordship. So far, the petitioner is concerned.
What's the other petition number?
And moreover, my lord will appreciate that this very committee which recommended for promoting the respondent before, the very committee was under challenge before this honorable court. And this honorable court is made clear in the earlier petition in the orders.
That has not been annexed, Your Lordship. Writ petition is 13 of 2024.
Order dated 8/2 of 2024 passed by this honorable court in the earlier petitions. The function of the managing committee will be subjected to further order of this honorable court.
It has not been included, Your Lordship.
I have not included it.
Why? Yes, heard Mr. S.M. Suna, counsel for the petitioner. Stop. Issue notice, Mr. Initial letter EAG with you. With Abraham?
Lordship, yes.
I was assisting, yes, Lordship.
Yes. Which also express accept notice will be held for respondents.
1 and 2, Your Lordship.
3 and 4 takes time.
3 and 4 within 3 days. Stop. It has been submitted by letter counsel for the petitioner that after the challenge to the reconstitution and management committee by way of LPC 1324, the petitioner who was
head teacher
holding charge as who was the head teacher by the impugn order now has been reduced to an assistant teacher with the respondent number 4, having been appointed by the impugn order dated 5th Feb 2024. Stop. But this order is 5th. When did you move your petition?
I moved a writ petition on 8th.
So that time they were not aware of the.
Yes.
We
are not aware of that.
They're not aware of the.
Lordship, another aspect of the matter, if I may point out, Your Lordship, there was a resolution of 20th, from the impugn order itself, Your Lordship, 20th/1/2024, Your Lordship. This is the resolution of the resolution of the Managing Committee. This resolution of the Managing Committee, Your Lordship, has not been put to challenge before Your Lordship, because this order of 5/2/2024, Your Lordship,
I am a member of that so-called committee, but I have not been.
This is a consequential order only, Your Lordship.
It is an approval. Doesn't matter. Once it's approved, this is an order, whatever it is. It's a standard.
Because this approval was
once this order is
the approval
order goes,
came out, Your Lordship.
Even that resolution also consequential.
On the basis of the resolution of the Managing Committee, Your Lordship, which was not before Your Lordship.
No, it's not like that, because before that, not after the challenge, that the reconstitution of the present Managing Committee is also under challenge before this court. He submits that the impugn order is questionable in as much as he has been functioning as head teacher since
2001.
2001 has been made with a view to intimidate her for challenging the reconstitution. So, as it may, we'll tackle it when the
Lordship, yes.
Yes, as it may, this is matter after 3 weeks. Ensure service. Petitioner can ensure service by, apart from its AD through.
And then the petition next date on 1st March.
And the impugn order shall be. They also pray for interim stay will be taken up on the next day.
Lordship, that is the writ petition number 30 or 13 of 2024.
Together. When is it being listed? 13th?
1st March.
Let's together for 1st March.
Meantime, my lord, impugn order may be stayed.
See, because the thing that if it had been passed after the 8th, then court will surely intervene. Yes. But since passed on the 5th, so it means before you approach the court, they had done all these things. Yes. It doesn't matter. We'll
it was passed without my knowledge.
That will take up. We'll punish them. Don't worry. If there's something wrong, we'll strip off the Managing Committee. We can't allow these kind of things to carry on. In all these schools, this was happening. There's one big fellow coming around. The other people, they had a meeting. He doesn't attend. He comes, forms own. He circulates signatures. Poor villagers sign. So it's not. The whole education system is wrong because it's based on these management committees, which are at the mercy of village elders and all. There should be a streamlined thing.
Item number 2.
Yes.
May it please Your Lordship, I humbly pray if this matter may be taken up at the end of the vote, Your Lordship, as the DHI is on legs, Your Lordship, before the division bench.
Why? Where's your senior?
He's on legs, Your Lordship.
Take him power to the screen, right?
But Your Lordship.
Item number 3.
Well, on basis of the instructions submitted yesterday, my lord, I have instructions to withdraw the matter as of now. But then, my lord, some liberty may be granted because even though the matter has been forwarded under 145, my lord, no action has been taken till now. Let us await some time. So, my lord, liberty may be granted.
Then counsel submit instructions. He may be permitted to withdraw this incident petition. However, liberty to file a fresh is so advised. Accordingly, matter stands close to withdrawal with liberty as prayed, with liberty granted as prayed.
Daily list item number 1.
This is.
Where's the affidavit?
Yes.
Your Lordship, we're still awaiting instructions regarding.
When was this moved?
But
this was PC number 30. This was filed as far back as 1 year ago.
1 year.
In the month of February, my lord, 17th of February.
Yes. Till now, no instructions.
Your Lordship, we're trying to communicate with them, Your Lordship, but there's some.
Trying to communicate?
With the department, Your Lordship.
Which department is this?
MORT is one.
They say since it's an old work order of 2007, so they're not able to trace the record.
What to do?
Your Lordship,
How much further time they require?
3 weeks, Your Lordship.
MS Argurung, right?
E. Guru.
Oh, Guru, sorry. On behalf of the respondents number, that's respondent number 4, submits that as the work, as the contract in question is of the year 2007.
Yes.
Yes, complete instructions are yet to be received. So she please consider further 3 weeks time to obtain the same and to file affidavit. Yes, list thereafter.
Item number 2.
Lordship.
Finish.
Please,
Affidavit ready?
Lordship, affidavit we had prepared and sent it to the department. They have sought time for considering and they have sent the matter to the finance. Your Lordship has been kind enough to accommodate us on many occasions, but yesterday I'm told they had a meeting and they want one more chance to.
Okay, as involved financial implication, yes. As paid for the 2 weeks time granted to the responsible affidavit.
Item number 3.
Wait, please, Your Lordship. Your Lordship, in this matter, Your Lordship, we would like to file our rejoinder. We're praying for 3 weeks' time, Your Lordship.
We already gave you last time, so list the matter February 15th for a joint affidavit, if any.
Yes, Your Lordship, a little bit more time is
Oh, you're not
required, Your
filing.
Lordship. A little bit more time is
You'll be
required.
filing?
We'll be filing, Your Lordship.
Okay, MS Mauri, so please for further 2 weeks time to file the joint affidavit, list thereafter.
Right, Your Lordship.
Item number 4.
Lordship, the respondent number 1 has filed one application. Lordship, I will file my affidavit in reply to that, Lordship, by the course of the day.
Number 1's whom? Who's the pin number 1? Cloud.
I have filed the application, respondent number 5. This is that matter on the last occasion, Your Lordship said restrain both the sides from not harvesting the disputed area.
Lordship, I will find my reply to that during the course of the day, Lordship.
So, Miss Case?
In Miss Case.
Miss Case?
Miss Case, Lordship.
Miss Case, yes, number 7.
Yes, Lordship.
Yes, Miss Case number 7, Mr. H. Cloud, praise for loud. Mr. H. Cloud, the counsel for the petitioner. Counsel for the writ petitioner. You are the opposite party number 1 here. Petitioner praise submits that the reply to this application will be filed in the course of the day. We're going to list this matter along with the main case on the next date. And the main case, what do you want?
Well, affidavits have been filed. The rejoinder is
by whom?
By respondent 5 by them.
You have a rejoinder to the main affidavits? No.
Yes, Lordship, I will file.
Yes,
and other respondents have not filed their affidavits.
Who has not filed?
District Council.
District Council hasn't filed, Your Lordship.
You won't file?
Your Lordship, I have to seek instructions, Your Lordship.
Why? This matters. Before when the matter comes, the list you seek, because
Your Lordship, actually my seniors on its legs in DB.
this matter, because the list comes a week before, all matters you need, that is why the list is published 1 week in advance, except for materials of such matters. So all councils are, it can be.
Your Lordship is on its legs, Your Lordship, that's why, in DB.
What to do? Then it's noted that the...
Lord, in fact, if I may just indicate, order dated 4th of December 2023, Mr. Kanta had made a statement that no affidavit is forthcoming.
Oh, then fine.
Another respondent is there, Lordship, same of Khairim Simshim. Of course, he is pro forma respondent.
He never filed?
He never filed.
Has he been served?
Lordship, yes. Lordship.
Ms. Shilla is appearing.
What about government?
Government is not a party.
Government
is not a party.
Number 6 is whom?
The same, my lord. Oh, sorry, my lord.
Yes, yes.
No, in the main case. You appeared last time.
Yes, Your Lordship, on behalf of Ms. B. Your Lordship.
That's the same, appearing for the same. State is not a party.
So just take down. Kharlor is whom?
Kharlor is...
Kharlor is my...
Rejoinder, okay. You filed, for 5 you filed.
Yes, my lord.
Yes, affidavit still awaited from respondent number 6, list the matter and so and so. And this, along with this case number so and so. Yes.
Item number 5. Item number 5.
May it please yours.
I'm praying if this matter can be taken up at the end of the board, my lord.
Is this batch matters?
Yes, my lord, batch matter.
Item 5 to 14, my lord.
Mr. Paul is here.
Paul is on
We'll
his
finish him up today.
my lord.
We will finish it.
15. 15.
Yes, madam. 15.
May please, Your Lordship. Your Lordship, the affidavit is coming today, Your Lordship.
Final positive is given.
I've already served him a copy also, Your Lordship. I've sent for signatures. It's coming today, Your Lordship. If not possible today, I'm praying for some accommodation to file it tomorrow.
I will find the cost of the day. Yes, you want to file a rejoinder?
No, my lord.
Mr. S.K. San submits a rejoinder if necessary. What, number 6 already filed?
Yes, my lord.
Yes, so this is a matter for hearing. Any urgency?
My lord, actually his due date will be on 25, my lord. Retirement. 25 next year, my lord.
Next year?
2025.
2025, my lord. Because, my lord, he was prematurely given retirement, my lord, by the
then this is for hearing.
Yes, my lord.
For 2 weeks.
16.
Hello,
May it please Your Lordship. Your Lordship, I'm praying for some more time to file my affidavit in this matter.
6. 6 Provident Fund.
Yes, Your Lordship.
We have received the affidavit from Provident Fund, Your Lordship.
You received the affidavit. MSZ inquiry prays for and allowed for the 2 weeks time for affidavit. I submitted that the affidavit on behalf of 6 has already been filed. Your file rejoinder to 6, no.
I'll seek instruction for that, Your Lordship.
It is after 2 weeks, yes.
Obliged, Your Lordship.
17.
Lordship, in this case, I'm for respondent number 1, Lordship. I need 2 weeks time, Lordship, to...
What is Miss Case?
This case has been filed by the District Council, Lordship.
Maintain with your petition. When was this filed? On the 9th. Who's appearing for the Sinong Cloud? Where's that? She was here just now. You've seen the Miss Case?
I'm not there in Miss Case.
You're not there in the Miss Case?
In Miss Case, I have received a copy of the Miss Case, Lordship.
You filed a Miss Case?
Can you grant us time, Lordship?
No, you are for the writ petitioner. Have you received copy of the Miss Case?
Yes, Lordship.
You filed a reply to this?
Yes, Lordship.
You already filed it?
No, kindly grant us time, Your Lordship. We'll file the...
Case 20-2024. In this application, which is challenging mental petition, the Mr. Ikasanti prays for allowed 1 week's time to file objections. Yes, in the main case?
I need 2 weeks' time, Lordship.
In the main case, Mr. Isnok
to file the affidavit.
number 1. Prays for allowed 1 week's time to file affidavit. Okay. This is the after also together with this case.
18.
Please, Your Lordship. I just want to apprise Your Lordship that this matter, like in first round of litigation, Your Lordship has appeared for those 7 villages and Snap Writing, Your Lordship, that's make Marbo. There's a claim that the Snap Writing has claimed that those villages are unit of Snap Writing, Your Lordship. The orders at page...
it hasn't come before me. First time it's come before me.
Yes, Your Lordship. That's why I just want to apprise that.
Let's see.
Page 101, Your Lordship.
Oh, yes.
Just want to apprise you.
Well, what happened to this case?
Now the District Council has streamlined, Your Lordship, that the headman of tendering cannot be the same person as the Saudar of not right tendering.
Yes,
so they have come against that order, Lordship.
What they have come against that order?
Yes, Lordship.
Well, that's correct, because tendering the village and it's not right, it's a right itself. This is a matter before any other bench wrote me. Right.
Hearing, item 21.
May I please, Your Lordship?
Are you still pursuing this matter?
Yes, my Lord. Now, Supreme Court has stayed the order of my Lord, which is passed in the division bench.
Regarding?
Regarding the compensation to be paid. So...
Oh, yeah, the state because said that it's too high.
Too high, yes, yes. So, I have talked to the mother. Mother is not keeping well. Probably she is old also.
What's the point of pursuing contempt?
Only thing is this, my message should go. What she also, I could have conveyed, she's talking in a local language. She is only to see that in future this thing doesn't happen, my Lord. Now, we are before this
contempt, then we have to follow up someone if, to example, but in this case, rightly, of course, contempt that Basu's judgment, that's fine. But then to proceed contempt, what will be?
Because, my Lord, kindly take note of one thing. That this is not as first time this incident are happening, that people are committing suicide when other 12 people are inside the lockup. And now, my Lord, not only that, they have perjured the document also. And they have filed an affidavit before this Honorable Court. Whereas the disease was handed over at 3 p.m. by the people who has arrested him.
Yes, we heard this one once, correct?
Yes, my Lord. Or let me just talk once more to the client. If she still insists, then I can argue the matter. Then let it come up next week only. Then.
Yes, request once more. This is matter after one week enable the council to receive instructions, to obtain instructions.
Yes, my Lord. After a week I will argue.
22.
Not the next issue of a food pay commission. Yesterday, my Lord.
Where's the development?
My Lord, we filed an affidavit yesterday, my Lord.
Where's the affidavit?
There are two things annexed, my Lord, in the affidavit. My Lord, one is order in respect of the cipher trade. And
he said that they are treating it, not treating it as a promotion, but treating it as a
resignation. In fact, today I got to know that similar order has been passed in case of pharmacist also, my Lord. That, however, I have not got hold of. And there is another order from the Kerala High Court where similar ORLs, my Lord, some of them who were posted there in Kerala, They had moved to the Kerala High Court, matter went to the apex court, it came back, and in contempt, my lord, the Kerala High Court has asked them to reconsider the matter. There's an order also in Annex A1 that I have filed. Same thing, my lord, this is WA Writ Appeal 50 of 2010, implementation of that, my lord.
Where's Dr. Mozika?
He's on legs, Your Lordship.
There's no purpose in continuing with this contempt then, Mr. Pathak. As the course of action has become diluted, it's become, it's many-headed now. It's not only, it's not a violation of one order, it's become sequential.
My lord, but then the issue is that, my lord, Assam Rifle has interpreted the order in a way they are, my lord, picking and choosing, for different trades, my lord, different implementations. They cannot plead, therefore, that we have understood the order in this manner only. For some trades, they have implemented it differently. For our trade, my lord, they have implemented it differently. No, but I think that in our trade, my lord, in our trade, my lord,
Yes.
In our trade, my lord, implementation in fact has resulted in reduction of salary rather than, my lord, increase, my lord. That is where it pinches, my lord. The entire purpose of the Fifth Pay Commission was to give better benefits. How
upgradation now? No, last time you submitted that this upgradation, they will not treat it as upgradation or promotion any longer. They will treat it as redesignation. Where's that order?
My lord, right, Annex A2.
Annex A.
But then A is A2, my lord.
Oh, you next it here.
Okay. Yes, my lord. Case 14. Again, that is in respect of the trade of cipher, which would be relevant in the next case in which Mr. Paul is appearing.
Yes, what did it say? Indefinite judgment dated so and so on, and budget visions on the judgment dated of the High Court of Meghalaya represent based on directions of MHA. I am like to convey the sanction. This is to be considered. Okay, that's good. And the recoveries will be, and also recoveries will be to reimburse. So you've got everything.
That is in respect of cipher, man.
Then with regard to your trade, we'll close this one. MS
In what we have got instruction, my lord. If at all there is an order, my lord, but whatever has been implemented is not by as per this order.
No, this is 2nd Jan 2024 order. You have copy of this?
We have received a copy, my
Of
lord.
2nd Jan 24. Then they've implemented. You said they've not reimbursed your. They will do it. Then you have the other cause of action, because there is a waiver to recover overdone pay allowance, and also this. You are cipher, correct?
My lord, yes, cipher.
Yes. Then this order covers you squarely.
I'm praying this matter will be taken up after some time, my lord. Mr. Paul is
All a matter of some time. Then
In that case, I pray for the same, Your Lordship.
after some time, they let Dr. Mozika and come, Mr. Paul come. But if that's the order, then nothing remains. If both of them, then because you agree with treating the resignation as a promotion and also the recovery, correct? And this court, I think last year passed this bench itself against the recovery and so on and so forth. Yes.
In fact,
yes, Mr. Pathak.
my lord, we'll wait for some time then.
Yes.
24.
May I please, Your Lordship? Conducting.
Start. You have the file with you?
Ma'am, sir, Conducting Council Seema Bhattacharya is on leave, so let the matter may come up after a week.
Oh. As the Conducting Council is on leave, this matter after 1 week. Yes.
25.
Much obliged. Similar matter. Connected matter.
Which one?
25 is also connected matter.
Your Lordship.
One is written, one is revision.
The review?
I know this is an Okma matter again, where the daughter-in-law is claiming the property after the death of the husband.
Okay.
26.
What is the contempt about? Violation of which order?
My Lord, if your Lordship comes to para number 16, my Lord, we have referred to that order.
16.
Para 16, my Lord. By the earlier, Lordship, para 16, page 8. This is our submission. That by the earlier judgment and order dated 17/3/2017, in the writ petition number so-and-so, it was held that once the matter is settled between the parties in the Lok Adalat, the matter cannot be agitated any further, but by the said letter dated 22/5/2020. Now, once again, the same matter settled by the Lok Adalat is being sought to be agitated afresh, without any fresh decision by any competent forum that any land of the Public Works Department has been encroached upon. Whereupon the said letter dated 22/5/2020 is in gross violation also of the judgment and order dated 17/3/2017. In para 17, in the readable, there was a readable earlier. There also by the said judgment and order dated 18/4/2017 in the writ appeal number 4 of 2017 before this Honorable High Court, a clear direction was given that if any department of the Government of Meghalaya has any grievance regarding the settlement before the Lok Adalat, then such department has to ventilate and project such grievance. But now the Public Works Department is seeking to enforce its own diktat without ventilating and projecting its grievances before any competent forum, thereby grossly violating their order dated 18/4/2017. So our case is that this the judgment given in the writ petition, as well as the writ appeal, are being violated. Now, if your Lordship would permit, may I take your Lordship to those orders, my Lord?
Yes.
This is the award. But at Anisha 4, my Lord, is the judgment and order dated 17/3/2017, that is page 17.
Yes.
Effectively from page 18, my Lord. And here the whole genesis of the thing is given, my Lord, if I can take your Lordship.
Yes.
Heard Mr. K. Paul, learned counsel for the petitioner, as well as Mr. G. S. Masar, learned senior counsel assisted by Mr. L. S. Darnay, learned counsel, and Chakravarti, learned senior counsel assisted by Mahanta, and the learned counsels for the respondent number 3, and Mr. S. Sengupta, learned additional senior government advocate for the respondent number 1 and 2. The brief facts of the petitioner's case is in a nutshell. The impugned award being passed in complete non-appreciation of the fact that dispute in question over the public road leading to petitioner and respondent's residence is actually a PWD road, and interestingly, the Public Works Department was not even represented before the conciliators. Now, my Lord, last paragraph, being highly aggrieved and dissatisfied by the impugned award dated so-and-so, passed in the revenue proceedings, the petitioner has approached this honorable court. My Lord, what has happened here, my Lord? There was a settlement arrived at in the Lok Adalat, and the Lok Adalat has granted the award also. Now, that was challenged here by the respondents in this writ petition.
Private respondents.
Private respondents. They had challenged that. And that was decided in this. My Lord, if I can take your Lordship, at that time, the senior advocate, Mr. G. S. Masar, I had appeared together with him. Well, the award is at, in the same judgment, it is given, my Lord, at page 20. The dispute between the parties having been referred for determination to the Lok Adalat, and the parties having compromised settled the case stroke matter, the following award is passed in terms of the settlement. I, Srimati Amelia Solia, do hereby agree to allow the right of use of 6 feet width out of the disputed area of 39.47 square meters permanently to Mrs. Srimati Twes Nongsej, respondent, without any future interference by me or my legal heir to the said area settled today. I, Srimati Twes Nongsej, and my future legal heir do hereby agree and is accepted to the settlement and shall have the right of use to the said area without interference from Srimati Amelia Solia, and shall have no claim or right to the ownership of the said portion of the disputed area stated above. Upon hearing both the parties and upon perusal of materials placed before this Lok Adalat, we are convinced that the settlement is fair, free from collusion, coercion, undue influence, being just, fair and reasonable as per terms mentioned above. The parties are informed that the court fee, if any paid by them, by any of them, shall be refunded. So the two conciliators were there, my lord, and the parties also have signed. Now, my lord, this challenge to the award, my lord, this was my lord, referred to the provision of the Act, Section 21, and then in subsection 2 of Section 21, it is clearly mentioned that every award made by the Lok Adalat shall be final and binding on all the parties to the dispute, and no appeal shall lie to any court against the order, against the award. On perusal of Section 21, subsection 2, it is amply clear that once the matter is settled between the parties at the Lok Adalat, the matter cannot be agitated further. So, my lord, the petition challenging this was not allowed, my lord. Now, there was a writ appeal after that, which is in the next annexure, my lord, page 22. My lord, if your lordship comes to page 24, effective part, my lord.
Yes.
We are unable to appreciate that the petitioner appellant seeks to question the award made by the Lok Adalat in her presence, with the suggestion as if the terms of settlement were not explained to her. Such kind of cursory suggestion against the sanctity of the Lok Adalat process cannot be countenanced, particularly when the proceedings do bear the signatures of the petitioner appellant and the signatures of the presiding officer of the and the conciliator. Secondly, in the present case, we find that by way of settlement, the respondent number 3 had agreed to allow the right of use of 6 feet width of the disputed area to the present petitioner appellant without interference, and the petitioner appellant agreed not to claim ownership of the disputed area. If the petitioner appellant has any grievance against the respondent number 3 about compliance of the terms of the settlement, obviously the petitioner appellant is required to take recourse to the appropriate remedies in accordance with law, but cannot question the award itself. The specious ground put forth in challenge to the award in question, that the PWD was not a party to the settlement, remains absolutely without substance for the purpose of this appeal. If at all any, this is the
okay. What happened after that?
Well, this sentence, Miller, taking advantage of this sentence, that if at all any department of the government carries any grievance,
what happened?
Has to be ventilated in a proper forum.
What happened after?
Now, Miller, after that, again, Miller, a notice has been given
to you,
Miller, because on the basis of this settlement, the wall was set up, allowing that 6 feet.
But it says encroach on the PWD road.
But now PWD again says that it has been encroached.
Yes.
Now, my lord, We have given, to that letter, we have given a reply, and we have brought out all the facts. Now, my lord, thereafter,
They were not party in the Lok Adalat.
No, my lord.
in our humble submission, my lord, they were parties in the litigation, and the matter was referred to Lok Adalat.
No, but that on that day when the settlement arrived at, their viewpoint was not taken with regard to settlement of the.
But if somebody does not appear, then what is to be done? In Lok Adalat is
What
sitting,
happened? Why,
all the
why
parties.
you come with contempt? That's what
Well, after that, my lord, again they had issued notice. We have again approached this Honorable High Court against the previous.
Who had approached this court?
In the next round of litigation, which is at Annexure 11, we are the petitioners here,
Okay.
assailing the earlier notice which was given to us. My lord, page 40. If your lordship comes to page 40, the effective area. After hearing the submissions advanced by the learned counsels for the parties, I am of the view that once the matter is settled in the Lok Adalat, it is a bar under section 21(2) to reopen it, which is also agreed by all the learned counsels for the parties present before this court. However, the question remains about the encroachment. If at all any encroachment is done, a specific law is available on what action is to be taken. But it appears that in one way the government is giving security to construct the boundary wall, and the other way notice is being issued to dismantle the wall. I cannot understand the position of the government, why they are taking diverse views and stand. If at all there is any encroachment by the petitioner, they should approach the appropriate forum, and the appropriate forum will do what is necessary after hearing and giving opportunities to the parties in accordance with law. Therefore, I find that in Annexure 9, the letter addressed to the petitioner dated 14th August 2017 has no stand in the eye of law. Accordingly, I set aside the said order. With this observation and direction, the petition is allowed and stands disposed of. Now, my lord, thereafter, identical notice is again issued, my lord, by the executive engineer, who is the respondent here. But, this is at page 42, Annexure 12, my lord.
Have you filed affidavit?
Yes, my lord.
You are appearing for the.
I'm appearing for only one of the respondents, my lord.
Who are the respondents?
There are two respondents, my lord. I'm appearing for respondent number 2, my lord, only.
What about number 1?
Number 1.
There is an observation earlier, I think, that the matter will not proceed against number 1 was the secretary, PWD.
Okay.
Secretary PWD, there is an order earlier that.
You are for Mr. Karmudai.
Yes.
Karmudai is the actual person. As observed on the various paragraphs in the Honorable High Court's order, after giving due opportunity of hearing to take appropriate steps. Now they are interpreting in a different way altogether, my lord. At page 42, my lord. Yes. As observed on the various paragraphs in the Honorable High Court's order, after giving due opportunity of hearing to take appropriate steps in accordance with law, you are hereby called upon to file your show cause reply, if any, along with your relevant documents to justify your occupation over the PWD land within a period of 15 days from the date of receipt of this show cause notice, failing which this office shall proceed ex parte against you. Now this is the notice, my lord, and then we have given a reply to that also, but there was no response to that. And then,
the thing is that as per your reply in the legal notice, you said that even in the proceedings before the revenue board or revenue whatever, you said that it is an admitted position that one part disputed portion of the land include a portion constructed by PWD during 2007-2008.
They had done some blacktopping and all that. But as far as the ownership of the land, my lord, we had never really. Anyway, my lord, that issue of whether they are owners or not If they want, my lord, they can.
What is your pointed? What is your submissions like with regard to how contempt has been?
My lord,
whether
the
contempt has been made
previous
out?
by the previous order, my lord, it has been the similar notice which was issued earlier, that has been quashed, that has been set aside by the Honourable High Court. Now they give an identical notice again, my lord. How can they do that? That is the case before your lordship.
Yes, Mr. D.
My lord.
As far as as far as the title and all that is concerned, whose land, what not, I think that proper appropriate authority will be a.
Go into that also.
Yes, yes.
It's just to whether there has been some willful violation of any order.
Right,
at
right.
all. Willful and made with a view to But if it's not willful, it's bona fide belief, then that.
They cannot come with the same notice which has been earlier quashed. That is my submission.
Maybe they have misunderstood. That's the only thing. Yes, Mr. D.
My lord, my learned senior has taken my lord to the learned single judge order. I will just cut short, my lord. Learned single judge order. I would like to take once again, my lord, to the learned single judge order.
The first one.
No, my lord. Page 40, the relevant portion of the learned single judge order, the last order of that is in para 9.
Yes, 9. Yes.
Yes. My lord, may kindly see para 9. If at all there is an encroachment by the petitioner.
No, para 9?
Para 9, page, yes. My lord, got it?
Yes.
Yeah. If at all there is an encroachment by the petitioner, they should approach the appropriate forum, and the appropriate forum will do what is necessary after hearing and giving opportunity to the parties in accordance with law, my lord.
Yes.
Now, my lord, may kindly see the notice, my lord, that we have issued. That is on page 42.
Yes.
Letter dated 22nd May 2022. My lord, as observed in the various paragraphs in the Honourable High Court's order, after giving due opportunity of hearing, to take appropriate step in accordance with law.
Yes.
My lord, this is very pertinent, my lord. Now they says, my lord, whatever we have to do as per law, my lord, we have to give them a show cause notice. That is our understanding, my lord. My lord, may kindly see my affidavit, my lord, page 15 of my affidavit.
15.
Yes, my lord. Para 15, page 15, the second part of para 15.
Yes.
My lord, got it accordingly.
Yes.
Accordingly, in compliance with the order of this honourable court, to
Notice one thing, Mr. D. Let's see the first order is set aside by this man, because the only case of Mr. Chakravarti is that it was an identical notice that was given.
Yes.
That was set aside by this court, and in spite of setting aside of the identical notice, in spite of setting a notice, an identical notice was reissued.
Yes.
Which they agree with. That is the only case, I think.
Right, primary.
Yes. Where's the earlier notice that's set aside?
Page 41.
Page 41.
The earlier notice. No, the earlier notice.
Earlier notice.
The earlier notice.
The notice which was issued.
Yes.
That is in page
Election
29.
9. That's election 29.
20,
Page 29.
Yes, annexure 9, my lord.
Okay, it's different. If this is the 14th August 2017 set aside.
Well, this was set aside.
Then, but the wording is different. It's not
Is it different? It's not identical.
See the second paragraph, Mr. Chakravarti.
Immediately dismantle the compound wall.
Yes.
From the said PWD road so as to enable the department to reclaim the above mentioned land. And here, my lord.
Yes, it doesn't say that.
Office should, they say, my lord, if you fail to.
No, it's you have upon to file a show cause you plan.
Yes, my lord.
That's all.
And our
So, my lord, point is that on the issue which has already been decided, my lord, how can they draw up a fresh proceedings?
Because they have been given that latitude.
No, that latitude, my lord.
Encroachment by para 9 itself, they should approach for a appropriate forum.
They should approach a forum, my lord. They should approach a forum. Whether
they should approach. Now, we're not looking at the legality of the order. We're looking at whether, contempt. We look from the compressed lens of contempt jurisdiction, whether there has been a willful violation.
My humble submission.
There is no willful violation.
My humble submission, my lord, here is that a notice of the PWD asking us, directing us to dismantle has been quashed.
Yes.
So just drawing up the proceedings by PWD itself without a judgment or a finding by a competent, either a civil court or a board of revenue, that they cannot do. And that is where the contempt.
But that is not in contempt. Because they don't know whether it's willful or not. For to their understanding, what I can gather, without encroachment issue, and what have they done? Giving opportunity to pass the control law.
So that is, they are reopening the matter of the, they are reopening the matter of, it is, contempt is for your lordship to, but my submission, my lord, is that where a matter which was initiated by the
has been conclusively decided,
how can they draw up again?
The cloud which has been created by Malan
Well, if they had given an undertaking also,
clear that,
even an undertaking is also not forthcoming.
Yes. My lord, may just clear this, my lord. Yes. My lord, may kindly come to page...
Oh, sorry, I feel you are not finished with that.
Yes, yes, my lord. My lord, now who is the appropriate authority if there is an encroachment, my lord? The law says is the deputy commissioner. Now, my lord, may kindly come to annexure 4, page 28, my lord, the lease agreement.
Of your affidavit?
Of my affidavit, my lord.
Yes.
My lord, may kindly come to serial number 8, my lord, the last portion of the lease agreement.
But this is not the petitioner's one, this is a twist long stage.
Sorry?
Yes.
This is the lease agreement.
Yes.
Yeah. That in case any dispute arise regarding the boundaries, the deputy commissioner and his representative shall cause the boundary mark to be erected if necessary after survey, and the cost of the erection of the boundary wall shall be borne by the lessee. The decision of the deputy commissioner in this regard shall be final and binding. So the authority according to us is the deputy commissioner to decide, my lord.
Then why did you issue the notice?
Now, my lord, this I will clarify, my lord, in page 15, my lord, of my affidavit.
Page?
15.
15.
15, my lord, of my affidavit.
Yes.
Accordingly, and in compliance with the order of the Honourable Court to accord an opportunity of hearing to the petitioner on the encroachment of a public road, the answering respondent has issued a show cause notice to the petitioner with letter dated so and so. It is to be mentioned herein that in case of receipt of the reply to the show cause notice, the same would have been forwarded to the deputy commissioner.
Have any bearing, because if you're governed by the Assam Land Regulation 1882, that means that your complaint should go to deputy commissioner first or to the settlement officer with regard to any encroachment.
Yes.
And then notice the issue from there.
No, yes, the proceeding there.
Grievances means that, like you see the encroachments there, you're not party in the local proceedings. So like you have recourse to other remedies. But like even then, say contempt made out isn't ignorance. If this affidavit reflects that, it means that the person himself doesn't know.
That is the confusion.
He doesn't know what action to take.
Yes.
That's why this court taking this view.
Ignorance of law, my lord. How can that be an excuse? My lord, if they give at least an undertaking that they will go to a competent authority and the matter will be pursued there, maybe deputy commissioner, maybe a revenue authority, we will pursue it there.
You just say that it was done and it was a
bona fide. See,
the thing is that it's a bona fide mistake.
It is not.
It is a bona fide mistake. It can make out because we know exactly, no one will want to stick out their heads for an official matter to like in these kind of cases.
They should give that much undertaking, Lord, that they will take it up with the competent forum, the competent, the proper proceedings. That much is also not forthcoming, my lord.
We should have come and got it quashed, this order, Mr. Chakravarti, also. Together
with the same issues, my lord, coming
even then, no, because it's what the court said and what they've done. Anyway, we'll pass order.
Obliged. Obliged.
Second call, supplementary list, item number 2.
By this order, we are challenging the order passed by the session judge.
Why writ petition?
Because, my lord, section 265G, my lord, here what happened, my lord, under the chapter of plea bargaining under the CRPC, my lord, the learned trial court.
Plea bargaining?
Plea bargaining, my lord, which is section 265A of the CRPC, my lord. Now, this chapter says, my lord, in case of a plea bargaining is accepted by a trial court, my lord, if for any offence a minimum sentence is prescribed, under plea bargaining, 50% of that punishment can be given, my lord.
Suppose 50 years or 7 years, a minimum punishment 7 years will be 3.5 years.
So
that's
here,
plea bargaining,
my lord. So here is a case, my lord, under 419, 420, and section 13A of the Prevention of Corruption Act, my lord. If I may just take your lordship to the provisions, my lord. I have quoted in the petition itself.
The provisions,
my lord.
Let's say it is a new matter. I mean, a new area which this court has not seen. What is plea bargaining 265?
265. My lord, first I want to take your lordship to the penal provisions, my lord. 419, my lord. Your lordship kindly sees
behind
page 6 of my petition, my lord.
Yes.
So 419 at the bottom, my lord, section 419 IPC.
Punish for cheating.
Cheating. Extend to 3 years, but there is no minimum sentence prescribed, my lord.
Okay.
420 also there is no minimum prescribed, my lord. But section 13(2) of the PC Act, it says, my lord, any public servant who commits criminal misconduct shall be punishable, shall not less than 1 year, my lord.
So minimum punishment is prescribed 1 year. That means if plea bargaining
is accepted by the court,
it's 6 months.
my lord. Now I'll take your lordship
But
to
then why if you come by writ?
My lord, section 265G, my lord, capital G.
What does it say?
CRPC, my lord. 265 capital G, my lord. G. Capital G, my lord.
Finality of judgment.
My lord. The judgment delivered by the court under section so and so shall be.
Okay. That gives you that language.
Only under 226 and 227. You can challenge this, my lord.
So are you taking this on 227 or 226? It will be clear because you can't maintain on both. It's been under Article 226 or under 227.
My lord, that is again subject to interpretation, my lord. If I read this, my lord, the judgment delivered by the courts under section shall be final and no appeal except a special petition under Article 136 and writ petition under Articles 226 and 227 of the Constitution.
So that means some judgments Supreme Court repugnant to this provision. With regard, you must take a choice.
You
can't maintain both under 226, 227. I mean, under 226 and 227 simultaneously.
Because in fact, what happened, my lord, we had to refile it because we filed initially under 226, my lord. The copying section, the filing section said that because "and" is used word here, so you have to file.
Yes, Advocate General. How do you reconcile this provision?
No, Your Lordship, in fact, there are judgments which permits filing of 226/227 both, my lord. That's
because there's a different view also, my lord. Because under 226 the writ appeal lies, my lord. Under 227 there is no
yes,
appellate
right.
That is the issue.
So if something is
the thing is that it amounts to a revision
yes,
or appeal against an order of a lower court or subordinate court. That is why.
So
that is why 227 would have been more apt.
Yes,
because if that order is totally without jurisdiction.
Order 226 fundamental right violation cannot.
Yes, exactly. Yes, that is why the view is taken by many judgments. That you have to take a choice. What does this change? Is a finality judgment. The judgment delivered by the court under section 265G shall be final no appeal except specially petition. Petition Articles 226 and 227.
That is because these 2226 and 2227 have been used interchangeably by the Supreme Court in so many judgments also.
In fact, this and should be read as or, my lord. But the filing section did not accept, so we have to file under 226 and 227.
So what happened? What kind of punishment was inflicted on the?
Till the rising of the court, my lord.
Till the rising of the court?
My lord. Considering
on
the
plea bargaining?
On plea bargaining, my lord. I'll take your lordship to the impugned order, my lord.
After being scolded, admonition is this?
Yes, my lord.
So you have to issue notice then. And you just see that, this is a judgment. Special CBI case number 2. Yes. Where's the impugn order? Where's the order?
Case 22, my lord.
22?
My lord.
Yes.
Para 24, my lord.
Yes.
The court is of the considered view that the accused, instead of being sentenced to imprisonment, taking into consideration her age and health condition, can be sentenced to undergo simple imprisonment till the rising of the court and released after admonition, and also a sentence to pay a fine of rupees so and so only for the offence under 419, 420 IPC, read with section 13(2) of the Prevention of Corruption Act.
Issue notice. Yes, heard Dr. N. Mozikala, DSGI, with so-and-so for the petitioner. Stop. The next part, the incident petition. Oh, so issue notice. Stop. Returnable in 3 weeks. We won't record anything. Let the petitioner to take steps within 3 days. Let's say ADS. This is thereafter 3 weeks. Very interesting. Suppose no minimum punishments prescribed, then 1 day is fine.
Then 1 day is fine.
So because one year is prescribed, that means
6
whoever
months.
is 6 months has to undergo simple imprisonment. And also this provision 265G also.
Item 22.
Mr. Paul, that was contempt matters, you know. Have you seen that
Well, it's that order that has been brought to our notice, Malaj. I'm relying on the affidavit filed by my learned friend.
But that'll answer your case.
Malaj, the only difficulty is, Malaj, insofar as the instructions from the clients, Malaj, as regard Malaj, there are two aspects to it, if I may. One part is, Malaj, that what we were saying all along, that now stands countenanced by this notification.
Yes.
That's one part of it, Malaj. Now, insofar as how they're applying this notification, Malaj, we do not know.
In fact, in contempt, we can't go there. The only thing is that your grievance is, that your upgradation, should be treated as a promotion, she was redesignation, and also the other repressions that we had dealt with here also regarding the recovery of, the...
That finds the reference in that notification, if your lordships have seen, Malaj.
Yes.
That finds mention in that
notification. That will be a fresh cause of action.
Well, it's the only thing is that because...
Let us close these contempts at least, because it's becoming a burden around,
Then file a fresh writ petition.
File a fresh
for a
petition.
subsequent cause of action.
Your lordships may, if I may just draw your lordships' attention to the orders passed by the Kerala High Court, your lordships have seen. Because the Kerala High Court, Malaj, the operative portion of the Kerala High Court, if your lordships kindly have a look at it. No, Malaj. Malaj, your lordships would find that at internal page 6 of the affidavit filed by my learned friend.
By Mr. Pathak.
Malaj.
Serial case 13, internal case 6.
Yes.
Well, it's in that view of the matter, there will be a direction to the second respondent to forthwith comply with the directions issued by the division bench and extend the benefits of the judgment of the division bench of the Guwahati High Court and writ appeal number so-and-so, as has been done in annexure so-and-so and so-and-so. Any stand contrary to the same cannot be countenanced. The directions shall be complied without fail from 8 weeks from today. If orders are not issued here and above, the second respondent shall appear in person. But it is only after these kind of orders are passed by your lordships, Malaj, that the notification comes into effect. Now, the difficulty with this notification, again, Malaj, if your lordships kindly have a look at it. Next page. 14. No? Well, it's in deference of the judgment and order dated so-and-so of Guwahati High Court, dated so-and-so and so-and-so Meghalaya High Court in WPC number 14416, and based on the directions of the MHA issued by so-and-so, I am directed to convey the sanction of the competent authority on the following aspects in respect of ciphers. The warrant officer cipher is to be considered as redesignation and not promotion.
Yes. That answers your prayer.
Now, the difficulty is, my lords, warrant officer would be class
2.
My lords, this entire difficulty can be put to rest, my lords, if it is given from the entry level. Now, what they are doing is, my lords, again it is complied again in part. So, warrant officer is class 2, my lords. So they leave out the entry level category. They said that from the warrant officer category, it will be treated as redesignation. In respect of the entry level, my lords, it continues to remain as promotion.
And if I may take your lordships to the operative portion of the judgment passed by this honourable court. If your lordships kindly have page 23 of the contempt application, my lords. No. PC Sharma.
This is Suvinder Singh.
No, my lords. This is
Malvindra.
PC Sharma, my lords. Item 23.
Page 23.
Page 23, my lords. I'm just reading the operative paragraph, paragraph 32, my lords.
Vice order.
Justice Vaish, my lords.
Yes.
In light of the aforesaid discussions, the writ petitions allowed, the respondents are directed to give appropriate rank and pay scales to the petitioners as per the 5th Central Pay Commission and Office Memorandum dated 22/1/1998, including financial upgradation under modified assured career progression scheme of the Government of India, if any, within period of 3 months. Now, my lords, the petitioners here would include the people of all the 3 categories. Now, what originally happened is, my lords, they came before with an order saying that it would be treated as promotion. Contempt was there for your lordships, my lord. I had also indicated to your lordships that the difficulty is with the word promotion. Now, they say, okay, very well, it is not promotion, it will be redesignation. Now, again, it has been done in piecemeal. My lords, and whether, my lords, every time they come up with an order, my lords, I would have to come back to your lordships seeking a clarification or seeking further orders from your lordships.
Have you got instructions on affidavit filed by Mr. Pathak?
My
Lord, may I point out one more thing, my lord?
But my lord, first thing, what I'll submit, Mr. Pathak's case and Mr. Paul's case are all entirely different, my lord, arising from 2 different orders.
No, Mr.
I am
Paul's
for
case is
ciphers.
cipher. His is for pharmacists and other trades, right?
Mr. Pathak is ORL, my lord, radio line operator.
Oh, okay.
Operator radio line.
Mr. Paul's clients are cipher, my lord.
Cipher is...
Cryptographers, man.
No, of course, no. I thought Mr. Chanda was for?
Ciphers, my lords. That's where your lordships had passed that order that there cannot be any recovery.
Order cipher?
Yes, that was cipher category.
And pursuant to that, this notification has been issued.
My lords, what I'm only submitting before your lordships is that it does not need to be done in piecemeal. Your lordships will kindly see that the writ petition which was originally filed, my lords, this was of the year 2014. We are in 2024. After so many orders being passed, my lords, and why I brought to your lordships notice the orders passed by the Kerala High Court, it is only when, my lords, then they realize that no, the water is actually reaching the nose, and they come and pass this kind of an order. Now, again in this order, my lords, they make it very clear, warrant officer. There is no requirement of this. If it is redesignation, my lords, redesignation from the entry-level post, I can, my lords, very safely say all litigation pending before all courts across the country will come to an end with that.
Yes, Dr. Modi, you take instructions.
My lord, in my case, I would point out, my lord, is that this clarification as to promotion and redesignation, my lord, has come in the case of cipher. But in our case, my lord, if lordship takes up my affidavit, page 15, initially it was said to be, my lord, redesignation. But then in final implementation, my lord, in page 16, the word redesignation, my lord, was to be substituted by the word promotion. So,
No, we remember
in
that.
our case, my lord, it's a promotion, my lord.
Where's the affidavit?
My lord, well, the 9th year, my lord, I think there's a 10 years life of this contempt application, my lord.
No, but
Well, that is why
the grievance are correct
my
also,
lord.
because
Yeah.
due to your own mistake, whatever you implemented or you allowed, and then you can't, try to, just like, slip and slide away by doing this and
My
that.
lord, our difficulty, my lord.
But that difficulty, of course, the
My lord, our
implications
difficulty, my lord,
are
is-
large, but even then, you
My
see,
lord, if
it's
there is a
very-
mistake, there's a direction by this honorable court, my lord. No, they're trying to drag the contempt application, my lord. And our case, my lord, in contempt application, there cannot be a substantive
Just give,
adjudication.
one simple instructions next date, and we will close it.
Why I
If
say this?
we'll close it in the sense that either we drop contempt proceedings and issue notice of contempt, or we close the contempt as not
Malaj,
being willful.
why I say this is, Malaj, what is very unfortunate, Malaj, your Lordship would have seen one paragraph from the Kerala High Court prompts them to issue a notification.
I don't think so, really.
Lordship's the date.
Because till they've been hanging over their head, I don't think, it's just they have to take a lot of time.
My Lords, the dates would bear me out. The dates would bear me out. That one line, my Lords, that fell from the Honorable Kerala High Court prompted them to immediately, my Lords, undo that promotion to redesignation. And that sorted out half the problem. What I'm only submitting, my Lords, is if your Lordships take a little strict view of the matter, my Lords, I'm sure this entire matter could be resolved by the Assam Rifles.
Where's the affidavit, Mr.
Your Lordships may at...
Yes.
I'm sorry, my copy is not paging.
Take it down.
Well, if your Lordships just have a look at Annexure A1 at page 7. The date of the order is, my Lords, 23rd of December. I'm sorry, my Lords, 5th day of December. 5th day of December, my Lords, this order is passed in the contempt. And on 2nd January, my Lords, the clarification comes.
Hello, may I add that Kerala High Court matter is coming up on 22nd, my lord, 22nd of February.
And this is also in a contempt application, my Lords. Your Lordships would have seen that.
They can't pass directions of contempt.
No, my Lords, I bow down, my Lords. That's the position of law.
What is precedential value of this kind of order, my lord? This doesn't have any precedential value.
No, I'm not saying it has any precedential value, my Lords. I say that it is of great persuasive value to the respondents.
It persuaded, what he's submitting that persuaded the Assam Rifles to issue the notification, that's all.
Because the moment, my Lords, your Lordships say that either you do it or you come here before the court, the notification comes.
Lord,
In fact, unless and until there is some twist.
Draw Lordship attention to only one thing, my lord. In my affidavit that was filed, not the promotion, the order clearly says it's upgradation, redesignation. Nowhere it says it's a promotion, my lord.
Which one?
It was treated as a promotion.
No.
If deprived them of the MECP or whatever.
It was treated as promotion, my Lords. I think that's order.
For practical purposes, even though it might be given, but then it was treated as a
But that is not their case, my lord.
We're not going to argue the merits of the case. We're in the contempt jurisdiction.
Well, Lords, my learned friend has just brought to my notice, my Lords, the query that had fallen from your Lordships, whether in contempt jurisdiction your Lordships can pass...
215. Article 215.
My Lords.
No, we are aware of that.
Well, there's this new judgment which has been delivered in 2024, my Lords.
Let us see. Was it your phone?
I'm sorry, my Lords, they just pointed it out now. This was on 30th January 2024. Justice Anirudh Bose and Justice Sanjay Kumar, my Lords, they have delivered.
What have they said?
Well, as the... where is that one you're showing me? If your Lordships just bear with me for 5 minutes, my Lords, we will ensure that we can have a printout and place it before your Lordships.
Just give the citation or whatever, or the reference.
My Lords, it is SLP number 34892 of 2014. 34892 of 2014.
Okay.
This is the neutral citation, my Lords.
Yes. Order dated?
And the judgment and order is dated 30th January 2014. 2024.
Okay.
When what it says there is contempt of court. My Lords, court can issue appropriate directions for remedifying and rectifying things done in violation of its order.
What not additional directions?
That would be directions, my Lords, for compliance of whatever is already...
I need a big question over that. Whether, okay, fine, under the High Court rules, maybe not, because it's strict contempt, 11, 12, whatever. But whether under 215, again, the scope is,
a little
expanded. That you can file.
Because, my Lords, the object of having contempt of court would be, my Lords, to ensure that the orders of the court are complied with. So if somebody is, my Lord, because the expression which we use, subversion is one thing, one is non-compliance, one is subversion, where I pretend, my Lords, that I have complied with the order, but I actually subvert it and I do not comply with it. I would say, this kind of a case would actually come in the second category. Please have a...
In fact, Lordship, I had placed earlier the decision in Gauri Shankar Prasad's case, in which also the Supreme Court issued direction. Prior to that, my lord, in Subroto Roy Sarkar's Sahara's case also, my lord, similar steps were taken by the Supreme Court, saying that the idea is to not punish, but then to ensure compliance.
But that's the Supreme
When
Court.
we see that apparently something is wrong, that wrong has to be remedied.
Well, I'm grateful to the learned Advocate General also, who was present on the issue of law. There's again another judgment, this is 2014 7 SCC page 416, where again in contempt petition, positive directions have been issued by the Honorable Supreme Court.
Volume?
This is 2014 7 SCC, page 416.
Okay.
This is the case of Bihar State Government Secondary School Teachers Association versus Ashok Kumar Sinha.
That Jharkhand case.
This is authored by Dr. Sikri, as he then was.
Okay.
My lord, I filed a synopsis, my lord. In this matter, I filed a synopsis of my arguments. There I pointed out, my lord, if lordship kindly sees para 3 of this, my lord.
He lost synopsis in Mr. Pathak's case.
I can give another copy, my lord.
1 second.
Let's see, synopsis written out in there.
This is in that matter. In Madhavan.
Basically covered both. Para 3, my lord.
Yes. What do you want to say of para 3?
Well, we've quoted one office memorandum of central government, my lord, which says that any financial upgradation will be set off against one ACP or MACP, my lord. Now, unless there is challenge to this notification, my lord, or there is a substantive adjudication by this honourable court in a writ petition, my lord, that this provision is not correct and it will not be set off against one ACP or MACP, my lord.
Not an issue that was adjudicated in this matter, and this defense was never taken by the state, the Assam Rifles.
This is where they want to stretch this the content application, my lord.
What is the synopsis? Filed by them.
So this you advanced this case before. This is abridged litigation whether which has not been argued.
That was not even an issue before the writ court.
If that has not been argued, whether that can be placed reliance on at the stage of contempt. And
that was not the
they
case,
were the appellants before the division bench. They were the appellants before the Supreme Court. Not in one case, in repeated cases.
My lord, what was their case before the learned single judge, my lord? May I just read the operative part of the order, my lord? What was the direction given by this honourable court, my lord?
That's a revised order.
It simply says Fifth Pay Commission.
You accord the appropriate rank and pay
structure as per the Fifth Pay Commission. Fifth Pay Commission says, my lord, they are entitled to Havaldar. We have upgraded, redesignated them as Havaldar, my lord. Now, after that, how the pay is to be calculated, my lord, from 1997 onwards, and whether this upgradation can be set off against one ACP or MACP or not, my lord.
Now you see as per that it has to be set off.
But the office memorandum says it has to be set off, my lord.
Whether that plea was brought.
That was not the case, this
So
set
his
up case
is
before the
that
literate
he was
court.
never brought because that OM saying that the set off is there was never challenged. That's the only thing. And his case is that now by the contempt you're trying to press accelerator, to say that even that goes under the bridge.
If that be the case, Milods,
yes,
I would again come back to the new notification of 2024 which has been issued.
Yes.
Now when they issue that notification, my lords, the word, which is why, my lords, I had pointed out in the first place, it is very interesting. They use the word promotion or upgradation and did away with redesignation. Now, my lords, when it suits them, they again, my lords, revert back to the original expression of redesignation. Now what happens to that notification? Because the moment it becomes redesignation, my lords, there is no question of setting off anything.
Well, I can undertake if they file a writ petition, my lord, within 15 days I'll file an affidavit, my lord. Writ petition can be heard.
The lordships will decide the matter, my lords. They'll carry it in appeal before the division bench. Then the division bench appeal will carry on to the Supreme Court. And then, my lords, we'll probably be back in a contempt application before your lordships.
Okay.
It's not against my learned friend, my lords. It's just the conduct of the Assam Rifles. It's unfortunate, my lords, that people have to run around for a limited relief.
And after
that is why I am submitting that it is willful. They are doing it as per their will, man.
And after it's been filed
Not as
by
per orders of
the, this is the petitioner
in 23, my lord, 23 or 15.
This is item 22, right?
Item 22, my lords.
Item 22. So bring on record. An order dated we will record an order dated 2nd Jan 2024. Stop. Dr. Mosika, you say that with this order, everything is over, right? Yes.
The way we are implemented, my lord, that's full compliance with the order.
Dr. Mosika submits that with the issuance of the order dated 2nd Jan 2024, the same is in full compliance of the orders referred therein, and as such, there is no further cause to continue with the instant contempt application. Stop. The same resisted by Mr. B. Pathak as also by Mr. K. Paul, appearing in a connected matter. The advocate, in the sense that though it appears that the judgments as given or to be implemented, the same is still not clear as to when it is to be implemented. When is the, what do you call it, redesignation is to take. That's what
applied.
Yes, applied, yes. Dr. Modi will obtain instructions on this aspect. Arun will hear it and close it again. Listed, you obtain instructions.
Because the same exercise was done by the Kerala High Court, my lords. Again, that same order. Your lordships will see in that order that the court by an interim order had directed them to place a calculation sheet. Simply to understand, my lords, whether it has actually been complied or it is again a farcical compliance.
My lord, may please also add that whether it is 2nd January to 2024 will also apply to ORL. This is in respect of cipher.
Yes,
this will also apply
instructions
to
also to be obtained as to whether it will appear across all trades, as given the judgments referred in the said notification, said order.
Item number 5.
This is a batch of matters, my lord, and very 5 to 14, my lord. There are two ways to deal with this matter, my lord. One is, my lord, that if my friend agrees, my lord, the lordship will set aside the order and let the matter be heard on merit by the commission. On merit, because if I place few facts, my lord, lordship would recall that there was application number, your lordship mean, because there is some confusion about the application.
Made this case so complicated the last occasion that
Yes, that's why I have to simplify. I will simplify. Your lordship kindly note down the numbers only. 1 to 10 of 2020.
1 second.
1 to 10, IA number 1 to 10. Sorry.
Forgotten everything. When was this matter last heard?
IA number 1 to 10 of 2020. 6 of February. One to 10 of 2022. IA, my lord. In case number 11 to 20 of 2022.
In case number
11 to 10 of 11 to 20 of 2022. This is one set of case, my lord.
Yes.
The other set of cases, my lord, IA 1 to 10 of 2023. In case number 9 to 18 of 2023.
Okay.
So one is of 2022 and the other is of 2023, my lord.
Okay.
So far as the 2022 case is, my lord, lordship would recall that this is a case relating to termination of MOU. By interim order, my lord, the commission stayed the order of termination.
With that Bernihart
Bernihart Industries, your lordship had rendered the original. Your lordship has dealt with that judgment. Then I will just complete in 2 minutes, my lord. So then this case was there, one termination of MOU. The matter travelled to division bench, my lord. Division bench finally directed that this issue will be decided by the MSCRC on merit. So this is one part of the matter, my lord. In the meantime, for the year 23-24, my lord, the tariff order was issued by MSCRC, my lord.
Okay, these IEs are there.
Yes, my lord. MSCRC issued tariff order of 23-24, my lord.
New tariff orders.
New tariff order. In new tariff order, there was no provision for a special tariff, my lord.
Yes.
The petitioner here, the respondents here in my lord, they filed review petition seeking review of tariff order, my lord. 23-24. And they also filed IA, my lord, for interim orders.
Okay.
So there are two sets of matter, my lord. One with regard to MOU, my lord, and the other with regard to
by the commission in one order.
That is what I am trying to. There is a confusion, my lord. That is what I am trying to clear the facts, my lord. So what has happened, my lord? The hearing was going on in, my lord, because IA 1 to 10 was already disposed of in 2022 because by interim order of MSCRC, my lord. They sought stay of the termination of MOU. They succeeded, and ultimately up to this honorable court, the court said that the matter will be heard finally by MSCRC. MSCRC passed the order in December of 2022 staying the termination of MOU.
Okay.
That is the broad facts, my lord. I will take your lordship to dates also. That then the final matter, whether the termination is in accordance with the provisions or not, the final matter was being heard. Issues were framed by the MSCRC. Parties were the hearing was going on in that matter. In June of 2023, my lord, when the matter was listed for this MOU termination, final matter, after hearing, my lord, the case is that the learned friend client filed some review application on IA, which was objected to by the lawyer of MECL, saying that these have not been served, we have not received. The matter was, the notices were issued by the commission, and 30th June was the date given for filing reply in review application and IAs, my lord. The matter relating to final determination, my lord, final determination with regard to MOU termination, my lord, was listed for 4th July 2023.
Okay.
4th July 2020, which is impugn.
In the first batch.
In the first batch. Which is the impugn order before your lordship. 4th July 2023 is the impugn order before your lordship.
Yes.
Case of the petitioner before your lordship, and in 4th July 2023 order, the court passed the order in review application, IAs filed in review application.
So that means you won't be on the scope.
The IAs were not listed. My case was that IAs were not listed. There was no date, and there was no.
23, 24 years.
Yes. 23. This Your Lordship, IA 1 to 10 of 2020.
Were not listed.
Not listed.
Not disposed of.
And the order was passed, staying the recovery of electricity dues as per the tariff order of 23-24, my lord.
Okay, Mr. Paul, are you open to the suggestion? Now,
No,
if this
I
matter,
want-
if
my
you
Paul
agree
will
to the-
agree.
if
Will-
you
I will want
agree
to-
that, if you agree that yes, this matter was
Now, why
substantially
it-
not listed and like orders were passed inadvertently, whatever, by the commission.
I would disagree to a limited extent.
Yes,
but
the thing is
to
that
the-
if
in
this court
substance-
finds that in substance that if that's correct, I mean on factual, I'm not talking about pleadings, I'm talking about a factual situation. If that is a factual situation which you do not dispute, then on those
Two aspects, if I may just very
considerations-
quickly point out, Milits,
Yes.
on facts. The special tariff was for a period of 3 years, Milits.
The MOU.
Yes. Special tariff was for a period of 2 years, admittedly. Now, what had happened is, Milits, originally they had terminated the special tariff. They terminated, invoked clause 17 and terminated the special tariff. We came before your lordships. What my learned, the Advocate General has placed before your lordships, Milits, matter went to division bench. Division bench said RCs to decide the matter.
So this court also said that MSRC is decide.
No, your lordships had held that the termination is illegal. It had to continue for a period of 3 years.
Okay.
No.
What had happened is, Milits, if I may, the order of the MOU, Milits, was incorporated and made part of the tariff order. That's where the confusion arises, if I may just clarify.
Part of the fresh tariff order?
No,
it was not part of
part of the old tariff order. I do not dispute what my friend is saying, Milits, that in the new tariff order, that did not come. Now, the tariff order comes in the month of March. 31st March, for effective 1st April, Milits, the tariff order comes into play. Now, till 31st March, Milits, that's where the first round of litigation was there, first batch of petitions before the MACRC, where we were saying that we are covered, since the tariff order says that, we continue to pay that. Now, the fresh tariff order came, Milits. In the fresh tariff order, for some good reason, the special tariff was missed out. So, we immediately filed a review saying that we are already protected by interim orders passed by this commission for the remainder period of 6 months. Kindly allows us to pay that because the main matter is yet to be adjudicated by yourselves. So, till that period of 6 months, the matter can be, we can continue to pay the old tariff because MACL, Milits, started raising the bills as per the new tariff.
Okay.
Rightly so, because their contention is, Milits, the new tariff order did not have the provision for the special tariff. So, as such, we are not bound by that. We would have to raise the bills as per the new tariff. Now, our contention was, Milits, that there were already effective orders of 5th December 2022. If I'm not mistaken, Milits, which said that we would continue to pay the special tariff till the period that the MOU was subsisting or such time that the matter is adjudicated by the MACRC. Now, the impugned order also says, Milits, and it makes it categorically clear, that whichever way the matter is decided, if the matter is decided against us, Milits, the entire tariff, residual tariff, which we would have not paid because of the orders of the commission, we would be required to pay them to the MACL. And Milits, MACL was directed that only for that limited period of 6 months, or what the interim order says, Milits, I'll take your lordship to the interim order.
We'll go into the merit, my lord. The issue is, my lord, that
just
one line, only on the fact, only on one issue, probably.
Agreeable to
No, it will
media kind of solution whereby the matter will be taken up.
What I was bringing to your lordship's notice, Milits, two circumstances have changed. One of the primary grievances, Milits, which is why the CDs and everything had been filed before your lordships.
That they were not heard.
I have not been heard.
And there was intervention by the law member.
No, I have not been heard. Matter was not listed, my lord. And what has happened, only this will end the entire issue, my lord. We have got the tariff as per the tariff order 23-24. We have collected, their case was that up to October 2023, they are entitled to a special tariff, my lord. So we have already collected the tariff. Main matter is pending before the MACRC, my lord. If they and the interim order which has been passed earlier, my lord, to that extent, now if they succeed, MACRC will pass the order saying that they are entitled to refund. And if I succeed, my lord, I will get the entire tariff. So therefore, as on today, my lord, this order, my lord, can be set aside and parties can be relegated to the court.
Which is what I said, Malaj. It does not need to be set aside. If it's set aside, it will create confusion.
There will be no confusion because
what the
ultimately
can probably do, Malaj. I agree with what my learned friend is saying. I agree with the learned, because that is the only bone of contention left, whether I pay them or they pay me. For 6 months, my lords, they have collected additional tariff. For the earlier period, my lords, I continued to pay the special tariff. So either way, whichever it is to be decided, it will be decided, and on the basis of that, my lords, the tariff will be fixed. If both parties agree, come to that consensus, my lords, that whoever wins the case will refund the money, that order can be reflected in the lodges and the matter can be
that is
disposed
for
of.
MSCRC to decide, my lord.
What I'm submitting is, my lords, you see, your lordships are relegating, because the challenge before your lordships is with regard to an interim order.
PNJ.
It's an interim order. Either way, my lords. Now, what my learned friend is saying, that if they are successful...
See, we don't want to, this court will not want to vest any rights or any, claims on any party.
Yes,
any actionable claims. The thing is that the only thing, if it has to go on a clean slate.
Yes.
It has to.
It
has to.
So we will not pass order, cloaking you with any kind of an actionable right or both, any of you. That's what I'm saying.
No, Malaj, I am not saying that these are orders passed by your lordship.
I'm saying that
what I'm
if
submitting,
it goes on those terms, that I don't want to cloak either the corporation or the petitioners or the respondents with any kind of an actual claim. Like if it is to go, it has to go on an independent assessment by the
Which is what is happening, Malaj.
No, because we have raised the maintainability issue. Consumer can't go. There are so many issues which we have raised.
All that the commission will decide. Cannot be decided here, which is why I was saying in the first place, Malaj,
what I was
not required.
I was submitting, my lord, that if the order is set aside, because now whatever we have collected the normal tariff as per tariff policy. For remaining period, they have given us a special tariff, my lord. And the main matter of 2022 with regard to termination of MOU is ripe for final hearing, my lord.
That is still not decided.
Not decided. And that is why
that was in the process of being decided when they came before your lordships and sought stay of the entire proceedings.
That's the root of the
They sought stay of the entire proceedings. It would have been decided by now.
So therefore, my lord, your lordship can dispose of with the direction to the MSCRC to decide the matter.
What has happened is, what we understand, what is being submitted by the learned advocate general, my lords, that in spite of the orders of the MSIRC, and which is
there is no spite. We have got the stay, my lord. We have got
stay came subsequently.
Whatever is there,
they have recovered the amount. That's not disputed. We had
while
to
the stay orders are operating.
Yes.
Though there is no stay, my lord. That stay was till the tariff, a special tariff, because we are bound by the statutory tariff order, and they, my lord, kindly see. Now I can, if there was a stay, my lord, they would not have moved the review. They moved the review petition seeking amendment to the tariff policy. If the stay was operating, your lordship kindly see their review application. I can clarify 217.
Malaj, I would not like to confuse your lordships. There are two aspects to the matter. After the division bench order, Malaj, if your
lordship kindly see 217 division bench.
Very confusing.
No, so the simple matter, my lord, is that there is a tariff order of 23-24 by the commission. We raised the bill as per tariff order. They said that special tariff was not included in the tariff order. They moved the review petition before the commission saying that please include the special tariff. That matter was not listed. Order came to be passed, saying that against which we came here before your lordship. Your lordship has stayed it, my lord. So now in the meantime, by virtue of your lordship's order, we have collected. For 6 months we have collected. Their whole case is that they are entitled to a special tariff up to October, which the commission has yet to decide, my lord. Commission has given order to collect the tariff as per normal tariff. We have collected the tariff, my lord. So all these issues, my lord, are before the commission now. We have collected the tariff. They have also paid the tariff to the extent of 6 months, and whether we are entitled to this tariff or not, as per tariff policy of order of commission of 23-24, or they are entitled to a special tariff. All these issues will be gone into by the MSCRC.
Well, it's what I'm submitting.
Yes.
What they did is, Malaj, my argument.
I have so many things to say, my lord.
We on facts.
My argument. Yes. Prior to 31st March 2023 was adopted by them in 1st April 2023. 1st April 2023, Malaj. Because my argument before your lordships was that irrespective of whether the MOU has been cancelled or not cancelled, the tariff order, which is, my lords, lays down the criteria for payment of tariff, provided for special tariff, so I was required to pay. So I continued to pay special tariff. On 1st April 2023, when the new tariff order came, 1st April 2023, when the new tariff order came, the same argument went in their favor. They adopted it, saying that since the tariff order does not provide for special tariff, you have to pay the regular tariff. That's the sum and substance of the matter. Now, there are two orders which are relevant. The first order is of 5/12/2022.
That's order of the commission.
Milord, let me place my case on merit.
No,
I know, because my friend is going into the merit, Milord. This is nothing but merit, Milord. What my friend is saying that 5th December order is continuing till October 2023.
No.
My friend is saying this is what.
If this is the way, see, we're trying to find a why media.
So
If
that
the
is
way,
what
then you submit, then let him reply.
Yes,
we'll decide on the merits.
I will do that. I will, Your Lordship. That is,
Since
I would like to. Your Lordship, kindly.
Sum and substance of the matter is, the matter will have to be adjudicated by MSARC.
So, if my friend is agreeing, the matter can be remanded back.
Where is the question of setting aside this order?
So, without setting aside, Milord, the issue only difficulty is complication will arise.
Your Lordships will only record that they have already recovered the tariff. From April 2024, April 2023 to October 2023, they have already recovered. And whichever final adjudication will be by MSARC.
Yes, I agree, Milord. I agree with my friend's contention. On this issue, I have no problem.
The reason why this order is to be set aside is because there is a contempt pending.
Because the issue is that...
There's a contempt pending.
Contempt meaning?
Well, it's because the 512 order was violated.
No, there is no violation.
According to us.
There is no violation.
There's no adjudication. According to us, it was violated, so we had filed a contempt.
Yeah.
No. Before the commission.
So, Milord, if
so
my friend
as
says...
long as, which is why we come to a why we
have contempt jurisdiction.
Well, under the Electricity Act, they have the powers. It's not really contempt, it is for compliance of the orders.
So that, Milord, as on today, my friend says that if the matter is remanded back for adjudication and leaving all the questions of law open, and fact, we have no difficulty.
And it's recording the submission that they have already
Yes,
recovered.
I have collected. That is
because it's a fact.
Milord, see, so far as the collection issue is...
These are talk at the same time, very difficult.
I'm sorry.
Yes.
It always happens when both of us are on the two sides.
Because it's very difficult, to...
My apologies. My apologies.
Yes.
So, to the extent, Milord, there is a consensus.
Slowly, so, if you can do one thing, you can... you consult each other and come up
with...
Have
a proposed order, and place before your Lordships.
Yes, that'll be better. Then both of us...
I think in substance, both of us agree.
Yes, that's what this court wanted to know.
We unnecessarily don't want to burden your Lordships with this huge bunch of matters. Because
so fine. So you come with a proposed order, this is your settlement, then that's it. I mean...
You can have it done tomorrow.
Yes, by tomorrow.
No, Your Lordship, today only just now we'll finish it.
We're leaving for Delhi in the afternoon.
Tomorrow.
Okay, fair enough. No, but Colney will be here.
No, I am also in some difficulty tomorrow. Right, so we'll try and finish it off.
Yes, you just...
We'll give it to the court master.
We'll
give it to the court master. That is the
My learned friend, Mr. Jindal's client, will actually adjudicate the entire matter.
If there is consensus between the parties...
I will not hear you also. You're not supposed to appear also.
I'll be the last person to contribute anything.
No, but why? You're not supposed to appear also. You're a what you call quasi-judicial authority. You're not supposed to appear to defend your orders.
Without taking up too much time, the law says that I can appear. I should appear.
Okay.
My difficulty is that I have especially fixed matter in Imphal, so tomorrow. So.
It is going to be a very short.
Hope we come back safe.
खत्म करवाइए क्या कर रहे हैं